Hello, good evening. We have a great subject tonight. I'm Debbie with Union Public Library. Just a couple quick messages. If you live, work, or go to school in Union, you can get a library card. You can borrow Chromebooks. You can borrow books on your e-reader. You can do so much without even coming into the library, but we hope you will. If you want to get information on future programs, just write the word yes in chat and I'll follow up with you. And if you can tell me what's of interest to you, that's even better. So tonight I would like to introduce, first of all, I want to say that this program is funded with a grant from the New Jersey Council for the Humanities. And that's very important because we are able to do special programs with them just because of things like this. So we're very lucky to have Assistant Professor of History and Director of the Law, Technology, and Cultural Program at NJIT, Dr. Alison Lefkovitz. Dr. Lefkovitz, can you get us started?
Sure, absolutely. I'm going to go ahead and start the slide if that's okay with everybody.
Please.
Share this. And then I'll start slideshow. Okay, so first of all, thank you so much for having me here and being here. I'm really honored to be part of the New Jersey Council of the Humanities Public Scholar Program. And then this particular one is the Democracy Conversation Project. And that's what connected me to Union Public Library System. And thank you also to Debbie Walter for inviting me and setting everything up so well, making a really beautiful flyer. I really appreciate all of that. And then you guys for coming out on a Tuesday evening. That's so nice. So my talk today is titled The Queer Housewives and Husbands of New Jersey. And it really begins with the premise that changes to marriage progress more strangely than we might expect, including in New Jersey. We often assume that, quote, traditional marriage advocates oppressed LGBTQ people in the past, but then LGBTQ rights inevitably improved as society evolved. But things progress more strangely in New Jersey and really everywhere. It is tempting to hope that New Jersey was a haven for LGBTQ people in this era, and this was sometimes true. I will argue that in each of these cases, we get some unexpected outcomes. Generosity towards some gay people, perhaps based on their gender or how well they conform to traditional expectations of being spouses or parents, but nonetheless unexpected outcomes. But ultimately, I'll argue that courts made these exceptions because they were exceptional. They did not challenge the status quo. Overall, even New Jersey couples were denied marriage rights, employment rights, and many other rights until gay liberationists began fighting for and winning rights. What they won through political organizations. In many cases, their victories remain fragile, and we'll have to think about how to maintain them over time. So this talk will use a few local court cases to think about the history of LGBTQ rights, marriage, and the law. The first part of the talk will involve two divorce cases in the post-war period, and one ended how you might think, but the other didn't. The second part will focus on a case of a 1976 couple where a New Jersey woman who is trans sued her ex-husband for alimony. In the third 1979 New Jersey case, the court allowed a lesbian to retain custody of her children, but at a high cost to her and to other couples. So that's an overview, but we're going to begin with the post-war period, in part because it really was as oppressive toward LGBTQ people as we imagine. In the post-war period, LGBTQ people faced a cruel social and cultural regime. Being discovered as lesbian or gay could lead you to being arrested, kicked out of the military, purged from your government position, fired from your normal job, ostracized by your family, lose your housing, be institutionalized, and much more. LGBTQ people were vulnerable to assault or blackmail by everyday people and by the police to avoid these fates. And this legal and cultural regime led many LGBTQ people to act covertly whenever possible during the post-war period. The stakes of being caught were immense. One place that people hid was in traditional marriage. And two cases that began here in New Jersey can illustrate how hard it was to be LGBTQ in the post-war period. So first, let's look at the 1959 New Jersey divorce case, HVH. Divorce cases were usually known by last name v. last name, but sometimes courts reverted to initials when they felt that the case involved a scandal large enough to desire discretion. At the time, the only kind of divorce available was a fault divorce. A fault divorce, for those who aren't familiar, required one spouse to be guilty of a legally recognized grounds that varied by state. So most states had adultery. Here's a little map from the New York Times. Yeah, most states had adultery as one of the grounds for divorce, but some states allowed divorce for abandonment or cruelty or other reasons as well. A fault divorce also required the other spouse to be innocent, i.e., they had not violated their marriage vows. So an innocent spouse won a case against a guilty spouse. There had to be one of each in a divorce case. Nor could the spouses collaborate to get a divorce. This was considered a collusion and you could just be denied entirely. A spouse who sued for divorce but didn't meet these standards could also be denied their divorce. They were just still married. So let's turn to the case at hand. H&H got married in 1949 when the wife was 25 and the husband was 19. The husband was a truck driver and she was an elevator operator even after they married. So already a little bit unusual. They had 2 children and owned a home in New Jersey. The trouble allegedly began when she started reporting to her husband that women would get into her car to, quote, try to make out with her. And things escalated from there. The wife started bringing women home and sometimes more than one. Since the husband traveled for his job, he would be gone for several days in a row. Then in June of 1956, the husband came home earlier than expected and walked in on his wife in bed with a woman referred to in the court records only as EF. The husband moved out and EF moved in. The wife admitted that she and EF slept in the same bed. And then the husband filed for divorce and he won on the basis of extreme cruelty. And this is the sort of case we might expect. Maybe not the brazenness that the wife illustrated. She only barely tried to hide what was going on from her husband. But certainly the successful divorce for him and against her is what we might have guessed. And if you're interested in more about these marriages where husbands either easily or uneasily knew about their wives' lesbian partners, check out Lauren Guterman's really amazing book, Her Neighbor's Wife. It's great. Things got stranger though when men cheated on their wives with other men in the post-war period. And take, for example, a man from New York named Louis Cohen, who had married Ruth Cohen in 1930. They had one son together. They were married for 17 years. And then in 1947, Louis Cohen traveled to Bergen County again here in New Jersey. There he was arrested and then convicted of the, quote, crime of sodomy upon a male person. He was sentenced to jail in New Jersey for not less than 7 years. I don't have a more detailed record of what happened to prompt such a long sentence. Perhaps Cohen had assaulted someone or the victim was underage. Though arrests were common, in fact, police often juked their own stats by pursuing the arrests of LGBTQ people. 7 years was a long time for a sodomy charge. But what happened to Cohen next is much more counterintuitive. His wife, Ruth Cohen, filed for divorce in their home state of New York, a state that allowed for fault divorce only in the case of adultery. For her, her husband's conviction clearly indicated he was guilty of adultery. I think we would think the same thing. The court, however, ruled, quote, the words sexual intercourse do not include the acts of carnal knowledge coming within the scope of the definition of sodomy, and cited English, Alabama, and North Carolina law for categorizing sodomy as distinct from adultery as grounds for divorce. The court ended the ruling by explaining that they were sympathetic to Mrs. Cohen, but powerless to act on her behalf because of the law. New York's strict interpretation of the meaning of adultery meant that Ruth Cohen remained married to her jailed husband. Without knowing more, I think we would have expected Lewis to be punished and Ruth to be treated generously. But this was not what happened. Did Lewis want to stay married? And even more so, why did New York want him to stay married? Perhaps Cohen thought avoiding divorce would save him further humiliation or disgrace. It would certainly save him alimony and child support money, and he would retain access to his child. Perhaps when he left prison, his wife would continue to provide household labor to him. But Cohen's wishes are less significant here than why he won. This case only partly reflected how difficult it could be to win a divorce in New York. It also reflected consensus among many judges that such husbands should stay married. Marriage, it was thought at the time, might cure homosexuality among men. Therefore, it was worth the burden on Ruth Cohen to ensure that Lewis stayed married. Nor was Lewis Cohen the only man who the courts tried to cure through marriage. In another case in 1963, again in New York, Virginia Freitag filed for annulment. She and Joseph Freitag married, and after a month of marriage, Joseph was struck with impotence. 2 or 3 weeks later, the quote, defendant, according to the plaintiff, confessed his history of prior homosexuality, and as to this revelation, the plaintiff professes to be aghast. Virginia also presented evidence that Joseph Freitag had consulted with a psychologist about his sexual identity and confessed his homosexual experiences prior to their marriage. The court nonetheless denied Virginia Freitag her annulment, ruling in favor of Joseph. Their reasoning was based on 2 facts of the case. First, Virginia had not left the marriage until a year after her husband's confession. Second, the court declared itself, quote, unable to conclude either that we have here a true case of homosexuality or that the condition of the defendant is incurable. Both before and after, the couple admittedly did have a mutual heterosexual orientation, apparently satisfactory to the plaintiff. For this court, men's homosexual activity could be a mistake, and a marital home with, quote, mutual heterosexual orientation could even potentially cure a man of his homosexual inclination. The hesitance to attribute these actions to a, quote, true case of homosexuality indicated that courts saw marriage as a possible cure. The court was less interested in punishing Cohen or Freitag and more interested in preserving their traditional marriages. But the courts were absolutely fine with punishing H and many other women like her. Gay men faced a great deal of oppression during the post-war period, but in the arena of divorce, they retained the privilege that men often held. So while we might appreciate the tolerance that courts displayed toward gay men, we shouldn't ignore how they treated lesbians. So now I'm going to shift to the second New Jersey case after the post-war period ended. Despite the system of arrests, divorce, lost jobs, and more during the post-war period, some LGBTQ people began organizing to obtain rights. You can see here, this image is actually from Chicago, but not unlike a lot of the protests across the country. This one is Stop Police Entrapment. This was a common source of organization for gay liberationists at the time, and it was even something they had common cause with African-American communities at the time too, that they would work together to try to defray police brutality as much as possible. This accelerated in the 1970s, and the goals of this movement were diverse. Some gay rights activists identified employment discrimination, the prospects of sodomy arrests like this, or still others, violence as the most pressing concerns. Alongside all these demands, however, some gay couples started to demand access to marriage. One of many strategies was to try to win marriage rights by getting a marriage license through subterfuge. The easiest way for a same-sex couple to get a marriage license was to trick the Marriage License Bureau into thinking the same-sex couple was an opposite-sex couple. Most of these men and women did not seem to identify as trans as it was understood at the time. Instead, they used passing on paper or through drag as a strategy to get a marriage license, not as their identity. Perhaps the most famous couple who passed in order to marry was Richard Baker and James McConnell. These are some wedding invitations from the 1970s that are in the Library of Congress. So just a sense that Couples were starting to marry informally in their churches, in their communities, but also fighting for the right to marry. But this is Baker and McConnell. So James McConnell was a librarian at the University of Minnesota, and Baker was a law student there. And Baker and McConnell believed that, quote, homosexuals should enjoy the same rights that heterosexuals do, including redress under wrongful death statutes, alienation of affection statutes, and one form of joint property ownership, which in Minnesota is available only to wedded couples. Baker elaborated that, quote, as long as society can get away with depriving rights to a certain group, that group will always be second-class citizens. And besides, Mike and I really do want to get married. Given his training, Baker was very aware of the legal tactics he would pursue, and the couple pursued two strategies simultaneously. First, they just sued outright for the right to marry. Also, some of you guys are law students, so you can imagine this is your life if it were the 1970s, perhaps. So first, they just sued outright for the right to marry, and Minnesota County Attorney George Scott countered their suit on the basis of the legal distinction between gender roles in marriage. He argued that, quote, granting the license would produce legal chaos because all of the law is written in terms of husband and wife, for whom different duties and rights are specified. And at the time, this was true. This was before the feminist movement had really altered the way that marriage law worked, that there were different expectations for husbands and wives. That said, eventually the Minnesota Supreme Court dismissed Baker and McConnell's lawsuit because what the couple sought, the court declared, was, quote, not a marriage. But again, Baker was a law student and he was very creative about how he could use the law. So that was technique number one, but while they waited for this ruling to come down from a state district court, McConnell adopted Baker in order to ensure Baker's right to inherit, to sue in case of wrongful death, and to pay in-state tuition at the University of Minnesota Law School. The couple also used the name change component of adoption to attempt to pass as an opposite-sex couple. As part of the adoption, Judge Lindsay G. Arthur approved Baker's name change to Pat Lynn McConnell. The new legal name was conspicuously and deliberately androgynous to allow Baker to pass as a woman on paper. The couple then took a short trip to Mankato, Minnesota to establish residence there. On August 9th, 1971, Mike McConnell went to the courthouse alone and applied for a marriage license for himself and Pat Lynn McConnell, whose presence was not mandated by law. On paper, Pat Lynn McConnell successfully passed as a bride-to-be. And perhaps they might have had a successful marriage license on the books if they hadn't already made themselves famous with the first suit. After the two obtained the marriage license, their names were listed alongside all the other married couples in the local newspaper. But at this point, a university publicist, originally from Mankato, happened to recognize the McConnell name and address in the list of marriage licenses in her hometown newspaper. The publicist notified the press, after which the county attorney at Mankato, John Corby, suddenly declared the license defective and unusable. Baker and McConnell litigated the validity of this license separately, and a few years later, it was officially struck down. Other LGBTQ couples also deployed this passing strategy to try to gain access to the broad range of marriage rights and responsibilities across the 1970s. As in Mankato, the Rockville, Maryland marriage law required only one party to be present. Michelle Bush and Paulette Hill successfully applied for a marriage license there. In this case, a name change wasn't even necessary. The two women seemingly took advantage of the similarity between Michelle and Michael, and the clerk claimed he issued the license unwittingly. The Maryland Assistant Attorney General argued that even though Maryland law barred gay marriage, the license would remain valid because, quote, the clerk has no authority to alter such records at a later point in time, either on his own initiative or at the request of the parties. Nonetheless, the couple had planned to be remarried in Washington, D.C., where a bill proposing gay marriage was considered and then defeated. They saw this as a safeguard because even a valid marriage license meant little given that Maryland held their marriage to be illegal. But gay couples' most publicized means of securing a marriage license was to have one spouse dress in drag while applying for a license. Again, these couples that I'm going to talk about now don't identify as trans. Later, I will talk about a couple where one of the members of the couple did identify as trans. So in October of 1972, Antonio Molina and William Billy Ert applied for a license just outside of Houston. And this is from microfilm, so it's not a great picture, but it's something to look at. So Ert, who worked as a female impersonator at a nightclub, wore a wig and a miniskirt to apply for the license. Deputy Clerk Sandra Kilinowski issued the license because she, quote, was most definitely under the impression that Billy was a female. Billy held their throat like something was the matter with it and said something about having laryngitis. Moreover, both presented valid voter registrations, driver's license, and social security cards. It was only after the two married using the license and then presented themselves to the press that the county clerk refused to accept the completed document for filing. Although the couple sued, the judge in the 130th Judicial District ruled with the county clerk. Similarly, in Las Vegas in 1977, two women obtained a marriage license in what the advocate called, quote, one of the first tries at a legal gay marriage in 2 years. I think I have a blurry picture of them too. Oh no, sorry, this is Molina and Ert. And this is just another couple. I don't think I talk about them. Christina Azumendi and her spouse, LT Cal Callahan, obtained a license because the clerk thought Callahan, who dressed in men's clothing, was male. The response from the state was more immediate and less confused by 1977. Quote, the newlyweds barely had time to finish a honeymoon before the local district attorney declared their marriage illegal because both spouses were women. For other couples, we don't know how they got their licenses. For example, much better picture, right? A Black lesbian couple in Chicago, Edna Knowles and Peaches Stevens, reported to JET that they had procured a marriage license without specifying how. And their idea was to hide the way so that they could share it with others. But from couples like Peaches Stevens and Edna Knowles, we can also see that the use of subterfuge was contradictory. The least successful passers exposed themselves to the press to make the point that gay couples were excluded from marriage rights and benefits. The most successful passers never made it into the press or to the attention of government officials. They might have lived their whole lives married on the books and socially according to their neighbors and friends. Perhaps they were childless, but many couples were because of choice, infertility, or age. But these passing couples also had no effect on either the law itself or public awareness of gay couples' exclusion from marriage benefits. So this is another attempt to use a valid license to get marriage rights by a couple who married in Colorado, but one of them was an immigrant, so it didn't work. And one of the rationales was that they couldn't have kids. So you can see that maybe it's a little too small, but it's in these, there's some headlines here about other kinds of marriages. And then here it says, sorry about the wording, but really a marriage does produce children, doesn't it? But as I was saying, passing couples had no effect on either the law itself or public awareness of gay couples' exclusion from marriage benefits. Historian Alison Hobbs has argued about racial passing that, quote, it was a phenomenon that by definition was intended to be clandestine and hidden to leave no trace. For LGBTQ couples who wanted to marry, the most successful passers left no trace, and certainly not on the law. LGBTQ couples who did reveal themselves attempted to create marriage across the country without much luck. These marriages raised awareness, but did not yield rights, or yielded individual benefits, but no awareness. So I haven't gotten to New Jersey yet, but now I will. And in this exceptional case, a couple was able to win very narrow marriage rights for a woman who was trans long before trans rights were even part of the mainstream gay rights campaign. Now, we wouldn't really group this case with the others I just mentioned because those couples did not identify as trans. We also would not expect a trans case to have been more successful than a lesbian or gay marriage case, but this was what happened. This was another case in which full names were not identified, and it was referred to as MT-VJT. And MT sued her ex-husband for support after he left their marriage. MT was trans. She had seen herself as a girl since a young age. She described herself as not playing sports and that she started dressing in women's clothing at age 14. She dated men. Her ex-husband met MT prior to her sex confirmation operation, and she told him her plans to have surgery. The two lived together in Hackensack, New Jersey prior to MT's surgery, and JT paid for the surgery. Once the surgery was completed, they were legally married. 2 years later, JT left. And like many divorces, MT decided to sue for support. JT claimed that because MT was actually a man, the marriage was void. He owed her nothing. MT refuted this by presenting evidence that she had performed the duties of a wife. The two had intercourse. The two cohabited until JT left. Moreover, JT paid for MT's surgery, and MT was financially dependent on JT for the duration of their marriage. MT claimed that JT was, quote, obligated to support her as a wife following the divorce. And surprisingly, MT was successful in her claims. The court ruled that MT, quote, at the time of her marriage was a female and that defendant, a man, became her lawful husband obligated to support her as his wife. The court even quoted an expert witness who claimed that MT's reproductive organs were the same as a woman after a hysterectomy. Why did this New Jersey court make a decision so unlike all the other decisions about LGBTQ marriage rights in the 1970s? First, MT was lucky to have her case heard by sympathetic justices in the lower courts and also in the New Jersey Superior Court. The court treated MT with a surprising level of respect and sophistication considering it was 1976. They used only she, her pronouns, and they conceded to the medical experts who explained that gender identity was more entrenched than bodily identity. The judges also dismissed the opposing expert testimony by JT's father, who happened to be a medical doctor. This was not a foregone conclusion, so part of MT's success is just luck. We can also look to the ruling itself. The court distinguished this case from two previous cases involving trans divorce by suggesting that neither was helpful. In the 1971 New York case, Anonymous v. Anonymous, the court ruled that the marriage between a non-commissioned officer in the Army and his wife, who was trans, was void because the marriage was not consummated, because the wife had defrauded the soldier, and because they had never had sex or lived together. The lack of consummation invalidated the marriage just as it would for a straight couple, and the fact that the husband didn't know going in was constituted fraud to this court. In a second case, MT-VJT, the court, this is about in regards to Mark B. The court made a distinction between the Mark B case because Mark B, quote, had not received any male organs and was incapable of performing sexually as a male. So this distinction suggests an inequality in courts between trans men and trans women, given the medical achievements at the time. But it also suggests that precedents in this case didn't neatly fit the sort of platonic ideal of trans marriage that MT embodied. One other factor why the New Jersey courts might have made this decision in the MT-VJT case was New Jersey's unique approach to alimony. Beginning in 1970, states across the United States began quietly examining their alimony provisions as they very loudly passed no-fault divorce statutes. prompted by former husbands, sympathetic judges, and even an emerging men's rights movement. And you can see that in these pictures. These are men's rights activists who are protesting alimony law at the time. Can New York afford honest divorce law? Close debtors' prisons now about having to pay alimony. Legislators did begin rethinking their state laws. So example, Charles Metz, who is the founder of America's Society of Divorced Men, believed that many divorced men were the, quote, unwitting stooges of conniving women, incompetent and equally conniving lawyers, and acquiescent judges based on the status of alimony, custody, and lawyer fee decisions in the United States. And Metz saw himself as representative of his club members. He and his first wife had divorced in the mid-1950s, and rather than pay child support, Metz chose to go to jail for 8 years, which is quite a decision. Metz remarried, but remained angry about the divorce. He published a guide to help divorced men navigate the divorce racket in the late 1960s. And it recommended 16 reforms, including abolishing alimony, ending the practice of husbands paying their wives' divorce lawyers, and granting fathers custody when it was in the best interest of the child. By the mid-1980s, nearly all the states in the United States made alimony a rare and temporary entitlement. But there were 4 exceptions, and New Jersey was one of them. In fact, alimony reform didn't come to New Jersey until 2014, when Chris Christie signed a new alimony bill. New Jersey politics were not attuned to letting husbands off the book, even so far as not letting JT off the hook for the support of MT, who in every way was a traditional housewife other than being trans. But I think the main reason MT succeeds is because the victory was still thin and insubstantial. This was a triumphant story for MT, but it was mostly a personal victory. Most LGBTQ people in the 1970s did not win the kind of marriage rights we would hope for, and the New Jersey court highlighted this case as exceptional above all. Judge Handler, writing for the court, clarified in the ruling that, quote, we accept and it is not disputed as a fundamental premise in this case that a lawful marriage requires the performance of a ceremonial marriage of 2 people of the opposite sex, a male and a female. Despite winds of change, this understanding of a valid marriage is almost universal. In other words, this single successful case rested obviously on New Jersey exceptionalism regarding alimony, medical progress, enough wealth to procure surgery, a sympathetic set of judges, and on the plaintiff's successful case that her femininity maintains sex difference in marriage. In many ways, MTV-JT embraced rather than overturned very traditional gender and sexual conformity. And MTV-JT was unique just as the court argued it would be. Certainly it didn't lead to marriage equality for gay men or lesbians. In fact, even though MTV-JT is really the only successful marriage case from this era that I could find, many states passed a ton of laws to ensure no more LGBTQ marriages made it through. And I'm happy to talk about more of these in the Q&A. But I think it is worth noting that historian Peggy Pasco argued that between 1973 and 1993, 18 states added formal same-sex exclusions to their marriage laws. And then between 1994 and 1999, 31 more states enacted similar laws. So I'm getting a little short on time, so I'm going to skip to the last case. The final way New Jersey LGBTQ people gained rights was to fight for custody rights. And this was in many ways one of the earliest battles among LGBTQ people for equality. You can imagine why. Gay men and lesbians in particular had married straight people and had children in the post-war period. Sometimes they stayed married and other times they divorced. But as soon as they divorced, the state had some say over whether they retained custody or even visitation rights to their children. The legal window of the day would have referred to the, quote, best interests of the child. Coming out meant possibly losing access of any kind to their children. Early post-war cases in this vein were largely lost or given up in the first place. If your husband wanted custody of the kids, if you were a lesbian who was out or had been outed, your best bet was to bargain with him. Often lesbian mothers would give up any claim to child support in order to retain custody. And if you're interested in hearing more about some of these cases, Radical Relations by Dan Rivers is a really good book on that. But as the 1970s wore on, gay men and lesbians began fighting for and even retaining their access to their children in many states. This wasn't guaranteed, and like now, it depended in part on what state you lived in. Texas, for example, was not a good place to try to get custody. And you can see here the face of a woman who lost custody of her son to her ex-husband for living with her girlfriend. You can see she's devastated. But sometimes LGBTQ parents won, and such was the case in New Jersey in MP versus SP in 1979. In MP v. SP, a woman fought to keep custody of her children. She had divorced in 1967, and even at the time, her husband knew that she was involved with a woman named Barbara. The wife won custody of the children nonetheless, and the husband visited one of the children, but refused to acknowledge their other child for years, until the mother finally convinced him to acknowledge both daughters. The case emerged years later, in part because the wife moved in with a new girlfriend temporarily. The change was indeed temporary. The new girlfriend didn't live in her daughter's school district, so the wife quickly moved back in with her parents. But the husband sued for custody on the basis of a change in circumstances. He won in the trial court, where the judge argued that the father offered a more stable home where the children would not be teased for their mother's lifestyle. The New Jersey Appeals Court, however, sided with the mother. In part, the court concluded that the father's home was not more stable than the mother's. In fact, he was behind $5,000 on child support, which is about $20,000 in today's money. Moreover, the younger daughter was highly dependent on her mother, in no small part, I'm sure, because of father's refusal to acknowledge her for so long. So these are crucial and legitimate reasons to keep custody with the mother. The court also disputed the father and trial court's claim that the older daughter was traumatized by her mother's sexuality. They said she noted it, but was not seemingly upset. The appeals court also argued that the older child could be embarrassed by the mother's circumstances, whether the mother had custody or not. Most of the court's decision was respectful and progressive for its time. But the actual basis for its decision was coming out of a legal consensus in not only New Jersey, but many places in the United States that was less progressive. This consensus was that even criminals could not be deprived of access to their children unless they posed some sort of danger to them. Now, this in itself, I think, is good law, and also made sense to cast gay men and lesbians as criminals, in that this was still criminalized at the time. Nonetheless, comparing gay men and lesbians to bank robbers, as a lot of courts did, is more unnerving. Courts granted LGBTQ plus parents parental rights, but within very narrow bounds. Gay men and lesbians could keep custody or visitation rights only if they agreed not to live with their partners, nor be politically involved. The MPV-SP decision states, quote, "Nowhere do we find documented in the record any specific instances of sexual misconduct by defendant or evidence that she tried in any way to inculcate the girls with her sexual attitudes. To the contrary, the evidence is affirmatively to the effect that she never displayed any sexual behavior in the presence of her children, and that she refrains from any demonstration of affection toward other women when the girls are present. Moreover, she is not a member of any homosexual organization." The fact that this wife had moved out of her girlfriend's house was undoubtedly a huge reason why she retained custody. Lesbians and gay men could keep access to their kids, but often at the cost of their relationships, their rights to free speech, and even sometimes their rights to community. Perhaps one more surprising thing to come out of New Jersey was that this standard was one that was imposed on straight couples as well, and even before MPV-SP. In the case of DeVita v. DeVita, the New Jersey court ruled that a father could lose visitation rights if he cohabited with his female partner. New Jersey based their DeVita's decision on a New York case that barred an LGBTQ parent from living with their same-sex partner, So it's really very circular, right? A gay couple in New York inspires DeVita in New Jersey, which affects a straight couple. And then DeVita is cited in New Jersey to keep the lesbian partners apart. Neither LGBTQ nor straight couples could cohabit and expect to retain custody of their kids. Straight couples, of course, eventually began cohabiting in New Jersey, but LGBTQ couples had no real security in their families until decades later. In fact, it took a concerted battle for marriage equality, involving extensive lobbying, consciousness raising, fundraising, protests, and cultural interventions for LGBTQ people to win some family rights at last. With Obergefell, for those who wished to, they could marry. And marriage gave some measure of protection over a broader family, though not entirely. It still varies by state how easy second parent adoption is, what happens in custody cases, etc. And now, of course, people are worried about Obergefell, although less so since developments even today in Congress to protect gay marriage and interracial marriage in the wake of the Dobbs decision. I'm happy to talk about this more, but I'll end just by saying that we must continue to defend LGBTQ's people's rights to form the families of their choosing. Thank you again so much for having me, and I'm happy to take questions at this point.
Thank you, Dr. Lefkovitz. Very interesting information. I wonder if anybody has a comment on that to start off with, and you should feel free to unmute yourself.
Here's just some references if you guys are interested.
Great. I also at this time am going to stop recording, but we're not going to stop the program just in case anybody has something they want to ask. But for the record, Dr. Lefkovitz, thank you. Okay, now I'm stopping recording.